Well, a very good evening to you all and to everyone who's watching this lecture online. Every year since before the millennium, the Four Inns of Court in London, in conjunction with the Institute of Advanced Legal Studies at London University, has invited a distinguished member of the Judiciary in one of our fellow common law jurisdictions to take up a fellowship in London. Candidates are usually nominated by the Chief Justice in their respective jurisdictions. Each has a topic of legal research which they put forward. The successful candidate is chosen by a committee chaired by the Director of the Institute of Advanced Legal Studies, Professor Cross-disciplinary, and comprising one bencher representative from each of the four inns. I'm the Inner Temple representative on that committee, and I've been asked to introduce our speaker tonight, the Honourable James O'Reilly, a judge of the Federal Court of Canada and the Federal Court of Appeal of Canada, because he is the 2023-2024 Inns of Court Fellow. James O'Reilly studied at the University in Western Ontario, Osgoode Hall Law School at York University in Ontario, and at the University of Ottawa. He was called to the bar in 1985 in Canada, and he was appointed to Justice of the Federal Court of Canada in 2002. In the course of his career, he's taught law at a number of prestigious Canadian institutions, including Carleton University, University of Ottawa, McGill University, Western University, and the Law Society of Upper Canada. The topic which he chose for his Inns of Court Fellowship research, and the topic on which he's going to address us this evening, is the process of judicial decision-making. We all know that in deciding cases, judges carefully consider, or they should do, all the documentary evidence, the testimony of any witnesses, and the submissions of the parties, and they then produce judgments explaining their reasoning and supporting their conclusions. Now, you might have thought this process has all the hallmarks of a strong model for sound decision-making. But the pressure of judicial business is ever increasing. Too often, there is little or no time for the judge to reflect. He or she has to think fast. Justice O'Reilly is interested in the factors that, for good or ill, may influence judicial decisions which have to be made under time constraints, such as decisions about injunctions, evidentiary rulings in the course of a hearing or a trial, decisions on oral applications for permission to appeal or to bring an application for judicial review, and in fact any circumstance in which an extempore judgment rather than a reserved judgment is required. In such situations, are judges more susceptible to unconscious biases and cognitive illusions, and of what kind? Are there ways in which judges can guard against them? As co-chair of the Judgment Writing Seminar of the Canadian Institute for the Administration of Justice since 2010, you might expect our speaker to have some answers to those questions. Please give a very warm welcome to Justice James O'Reilly.
Thank you for that very kind introduction, Mark. Let me just say that the Inns of Court Fellowship is a wonderful program, I can assure you. It's a unique experience for judges to share ideas with scholars at the university, as well as with barristers and judges and retired judges at the Four Inns. This has been a once-in-a-lifetime experience for me, although I'm embarrassed to say it's the second once-in-a-lifetime experience I've had having a chance to live and work in London. I had a chance to do so just over 20 years ago here as part of an inquiry that was called the Collusion Investigation. And ever since I left that job to go home to be appointed a judge in Canada, I've been looking for a chance to come back and have another once-in-a-lifetime experience, and I feel so fortunate that I did so this year. all have encountered, all the people I have encountered have been warm and welcoming and keen to discuss my very tentative ideas about judicial decision-making. Inner Temple has been very warm and welcoming and kind and generous, I must say, and Sir Mark has been a wonderful host. And I must say that his role I would describe as heroic in that he actually has heard this lecture before. He came and attended a talk I gave at the Institute for Advanced Legal Studies back in November. So thank you very much, Mark. So my title, let me see if I can get the choreography right. I'm in charge of microphone, clicker, and slides. See if I can get those all to work in the right order. So I started thinking about judicial decision-making about 15 years ago. And I came upon some literature in the area of cognitive psychology and behavioral economics. And this is a quotation from an author in the area who says you'd have to be living in a cave if you haven't heard about behavioral economics. There have been many popular books written on the subject, 2 Nobel Prizes awarded on behavioral economics in recent years. So there's a lot around, and here are just a few of the sources. These are some of the ones I started looking at. And when I was reading these, I thought, this is telling me a lot about humans' ability to make decisions and their tendency to be irrational, such as suggested by the first book there by Daniel Ariely, predictably irrational. Turns out that human brains are predictably irrational. The behavioral economists initially came to this subject to look at economic phenomenon, as the name might suggest. But these are psychologists, they're not economists. So Daniel Kahneman, Thinking Fast and Slow, he won a Nobel Prize in economics for his textbook on psychology. And that was because the thinking that he brought to that subject had a lot of application to how market forces work. And his discovery was that there was a lot of irrational thinking going on in how the stock market operates, for example, which is not that surprising perhaps, but even about more technical economic decision-making, he found that there was a lot of irrationality going on. And this was contrary to the principal line of thinking in economics that people are essentially rational actors and the market will act rationally because those who are involved in it will be acting in a predictable fashion. It turns out that's not to be true, and he had, in the course of his work, identified many areas where human thinking was flawed. I started thinking about it more concretely when I started looking at decisions of my own court, and there are a couple of empirical studies of decision-making in the Federal Court of Canada, particularly on leaves and stays, as I describe them. Leaves are applications for leave to appeal. These are done entirely on paper, and there are no submissions, there's no appeal, there are no reasons. Stays are similar, although we usually have brief hearings on stays. These are requests for stays of deportation. So the studies in this area have shown, I would think, some flawed decision-making, and I'm going to show you some of the data on this. Here's a table. You may or may not be able to see that, but in the first column there, I'll leave aside the second column for now. The first column of figures shows the rate of success of refugee claimants in our court who are requesting leave to have their judicial review heard. And the range you can see is 95.9% at the top of that column, 1.5% at the bottom. This isn't all the numbers, but I've given you a sense of the array of statistics that one would find in looking at these decisions. That's obviously a problematic situation. So if you're a refugee claimant trying to have your case heard in the federal court, you may have a 1.5% chance of success in front of Justice Crampton at the bottom, now my Chief Justice, or 96% chance of success with Justice Campbell at the top. So this is a serious problem, and there's a problem inherent in inconsistency, unfairness, inequality, appearance of arbitrariness, reasonable apprehension of bias, possibly, and certainly a reputation cost to the court and the judiciary. The court has publicly acknowledged that this is a problem and has undertaken to do something about it. So far, nothing has been done about it, which has caused me to be even more interested in the subject in the event that I might help to bring some ideas to my colleagues about how we could do things better. But I should explain also that this is a problem, I think, everywhere, particularly in refugee decision-making, which has to be done very quickly where the volume is very high. It's certainly the same in the United States, and I've quoted here Cass Sunstein, who's one of Daniel Kahneman's collaborators, and I think this is self-evident. If 1,000 people are getting asylum but do not deserve it, and 1,000 are not getting asylum but do deserve it, then we have a serious problem. And I think my court has that serious problem. We've looked at various things we might be able to do about this, and I would characterize these as procedural changes that we might be able to make, not assigning judges in their first year when they're not used to deciding immigration or refugee cases. By the way, the test on a leave application is the applicant is entitled to a hearing if he or she has shown a fairly arguable case, which is obviously not a very clear standard. It's quite vague and open to interpretation. So if one is skillfully going to answer whether a claimant has an arguable case, you have to know something about the legal issues that are being presented. So I thought perhaps we should leave the first-year judges out of this. But all of these solutions or partial solutions have resource implications. So that's one. We thought about having 2 judges decide these cases instead of 1. Again, that's going to have enormous resource applications. By the way, I got this number the other day. We had 16,000 of these leave applications last year. So quick math, we have about 40 judges. That means 40 judges are doing about 400 of these applications every year. You do 80 in a week, 20 in a day. So that means a judge will be assigned to about 5 weeks of doing these cases every year. It's very high volume. We thought about developing guidelines and criteria. I'll come back to that, possibly requiring reasons, but can you imagine the burden of writing reasons in 16,000 leave applications a year? So these procedural solutions, if they are difficult to implement because of resource implications. But because of what I had been reading in the area of behavioral economics, and particularly Kahneman's book on thinking fast and slow, I thought possibly thinking fast is the problem here. Because if you're doing 20 of these in a day, you're obviously not spending much time on them. Kahneman posits that we actually, as humans, have 2 ways of thinking. System 1, as he calls it, is fast, intuitive, and easy. That is, it doesn't take a lot of effort. But it's also prone to biases. When you're using intuitive thinking, you're apt to be relying on biases or cognitive illusions or heuristics, which I'll come to in a minute. System 2, on the other hand, is more slow, deliberative, and difficult. And as humans, we naturally tend to try not to use system 2 because our brain is inherently lazy. So we will try to have a fast answer typically to questions rather than deliberate and arrive at an answer more slowly. Because it takes a lot of energy. You know, Kahneman talks about how he likes to think while he's walking, but he says if he walks too quickly, he can't think. So thinking will actually physically slow you down. you're using mental energy and glucose and so on if your brain is active. And typically we try not to be active in the use of our brain cells, it turns out. But the advantage of system 2 is that it's less prone to biases and cognitive illusions. But the situation I've described in those leaves and stays in my court, not only is system 1 going to be used by the judges, it's essentially required, because you can have no more than an intuitive answer to the question, has this person presented a fairly arguable case, if you have to decide it within minutes. Note, though, that having a slow, deliberate process doesn't answer all problems, and I'll come to that in a minute, but certainly the thinking fast situation does cause serious problems. So we know that judges are susceptible to biases and illusions. There have been many empirical studies of judges, and really most of them show that we're not much better than anybody else in particularly as law students, for example. Judges are just about as good as law students in their decision-making processes. They're just as apt to be biased or to make errors, simple errors in calculations or in dealing with figures of any kind. But we know that some of these, and Kahneman has identified scores of them, and I'm not going to go through scores of different possibilities, but here are a few that are particularly germane to the legal field. Anchoring is one I'll come to in a moment. Framing, hindsight bias, you've probably all heard of. Egocentric bias, believe me, judges are susceptible to that one. Confirmation bias, certainly, and heuristics that I mentioned a moment ago are really rules of thumb that make difficult decisions more easy, and we often do this unconsciously. So I'll just give you a few examples of some of these problems. Anchoring. Here's a question that reveals how anchoring works, and the thing that's at the heart of this is that once someone suggests a number to us, we can't get that number out of our heads. So if you ask a group of people, what is the percentage of African countries in the United Nations? If you ask some of them, do you think it's higher or lower than 10%? Most of them will say higher, and on average, their answer would be in the range of 25%. But if you ask a group of people, is the number higher or lower than 65%? On average, people will say it's around 45%. So once a number is suggested to you, you sort of work off of that number. So at the low end, you're going to go higher, but you don't go that much higher. At the high end, you go lower, but not that much lower. So you have a range there of between 25 and 45%. The actual range is 28, by the way, but that's really got nothing to do with the problem. But this works in all kinds of areas. And here's an example I think I gave Mark at the last talk you were at. I usually give the example of what is the cost of my necktie, but I'm not going to do that today because you will all recognize this as being a Pegasus tie from the Inner Temple, and if you Googled it, you'll find out it cost 25 pounds, and it's in a display case downstairs with that label on it, so I'm not going to use that example. But how about Sir Mark's tie? I'll use that one. So if I suggest a number to you, do you think that Sir Mark's necktie cost 25 pounds or more? You will probably all say more, but you might not get much higher than 40. But if I were to say, do you think it's 150 pounds or less, you would probably say yes, but you would likely arrive at a number around 90 or 100. So it's a huge range, and it comes out of a purely arbitrary suggestion of numbers. And this works even if you tell people that the number that you're putting in front of them is completely arbitrary. So I study recently on judges coming up with calculations of sentencing. And this study is called Sentencing at the Roll of the Dice. And what this showed is if you had people, judges even, roll a dice, and if they got a number 3 and were asked, they were given a fact scenario and they were asked to come up with a sentence for this particular accused, well, would you sentence that person to more or less than 3 if you rolled a 3? And they would say more. Okay, how much more? 5 months. Okay. So another one would roll a 9, and would they be asked, would you sentence this person to more or less than 9 months? And they would say probably less. Well, what would it be? 7. So even if you have completely arbitrary numbers randomly selected, people can't get the numbers out of their head. And that's obviously something that may influence not just in sentencing, but in damage calculations or costs or awards or what have you. I told you judges are susceptible to, I've skipped one, I think. These are, put these in the wrong order. Okay, hindsight bias. So we often, as judges, have to decide whether a particular event was foreseeable. This would be true in negligence claims, and in my world, I do a lot of patent law, whether a claimed invention was obvious, and so on. It turns out, as Guthrie says here, one of the authors I referred to earlier, when predicting the likelihood of something after the fact, judges can't help but rely on facts that were unavailable before the fact. And this is obviously a problem if you're in that situation where you have to assess the foreseeability of a particular event. But our brains naturally create a narrative out of facts that we know. And we can certainly try to see what was known before the known event occurred. But the fact that it did occur is going to make it seem more likely that it was going to happen. And there are some famous examples of this in the law. It comes up quite regularly, in fact, but the one that struck me the most was a trial in Italy in 2009 where 7 Italian seismologists were convicted of manslaughter and sentenced to 6 years in prison for failing to predict an earthquake that took place in the town of L'Aquila that killed 300 people. So these seismologists had been doing measurements and so on before the event. They concluded that an earthquake was unlikely to occur and made public statements to that effect. And then it did occur. But to think that you could conclude that those persons are guilty of criminal offenses for failing to notify people that an earthquake was coming could happen unless you knew that it did happen. Right? And so I think that the outcome there caused those proceedings to be brought and those convictions to be entered. You may be happy to know that those convictions were later overturned, but it's an example of how hindsight bias may enter into legal reasoning. Egocentric bias, I told you judges would be susceptible to this. Most people are. People tend to overestimate their own skills and prospects, and this is good for us. It gives us a sense of self-esteem and well-being. But most people, if you ask them, think they're better drivers, parents, partners, all of those things than other people. And judges think they're better than their colleagues. If judges, when asked to estimate their own reversal rate at the Court of Appeal, most judges, 88%, said theirs were the lowest. Right? So 88% of judges think they're better than their colleagues. By the way, judges also think they're less biased than their colleagues. So here's heuristics, and I mentioned that this is a phenomenon where you substitute an easy question for one that's difficult. So I've taken a couple of quotations here from discussions about, within my court, about what to do about these statistics on leaves and stays. And I've only given you a couple here, but there are all kinds of them, and they reveal the reliance on heuristics in that situation. So, as I mentioned, the test is whether someone has presented a fairly arguable case. Okay, that's a very difficult thing to decide, in part because it's such a vague, open-ended question, but also because you don't have any time to think about it very much. So people come up with their own strategies, and a strategy is a heuristic. So here's one: I only grant leave where there is corroborative evidence. There's no requirement on a refugee applicant to supply corroborative evidence. So the judge who's deciding cases on that basis is not deciding whether there's a fairly arguable case presented by the refugee claimant. They've substituted an easier thing to answer. Similarly, I grant leave if the applicant's story fits with what I know about the country conditions. Again, that's not the test. That's not the way to decide whether the case has any merit. It's part of it, but it's not the whole question, but it's an easier thing to answer than the question that's actually being posed. And we do this all the time. We try to find something easier to answer. For example, if you ask people whether they think climate change is a real thing, most people won't have read the statistics and the scientific studies. They'll have read things that appear in the media, obviously. But a lot of people will say, well, I like Al Gore. He seems like a serious guy. I trust him. He's looked at it closely. So I think climate change is a real thing, and I agree with him. Another person might say, I like Donald Trump. He tells things just the way they are. I trust his judgment on that. He says it's a hoax. So it's an easy way to answer the question, a difficult question about climate change, but we tend to do so by using a simpler question to answer. That's called the affect heuristic. By the way, you tend to agree with people you like and trust, which is only natural. Now, do these things influence judges? Are there ever situations where judges like a lawyer or like a party or like a witness or just the opposite? Certainly, but can the judge put those things out of his or her mind so that the case is really being decided on the merits as opposed to which counsel was more impressive? But across the court, just to go back to my example about leaves and stays again and looking at those statistics, it's almost certain that under the conditions in which those decisions are being made, that all of this is playing a role, and it will be different with each judge. Some judges will have certain biases, some will have others. Some will be using some kind of heuristic, others will be using a different kind. So what you get is what Kahneman calls noise. You just get a bunch of data that shows that there's inconsistency across an institution, like a court, that is the product of this kind of thinking. When you have an accumulation of it across many different decision makers, you get that noisy result. A term I'd like to introduce you to is decision hygiene. And the law is a good model, as Mark said in his introduction, for good decision hygiene. When you have written and oral submissions by professional advocates on opposing sides, time to deliberate, writing reasons, getting feedback on the outcome. With our leaves and stays examples, there's none of that, absolutely none of it. It's the perfect storm for bad decision making. Some colleagues, by the way, in response to questions I've put to them said, well, I've been doing this for a long time, so I feel I'm an expert in this. There is no chance that they are an expert in deciding what is a fairly arguable case on a case-by-case basis. There is such a thing as expert intuition, but it's very rare, and it's the kind of intuition that a chess master might have, looking at it at the configuration of players on a chessboard. A very good player could say, I've seen this 1,000 times before, I know exactly how this is going to go. That's not judicial decision making. Judges can never have that kind of expertise. There are some others who do have it. I've read about nurses being quite good to have an intuitive expertise when someone presents with a certain constellation of symptoms. They're very good at saying you need this test or that test, or you need to see this doctor or that one. Firefighters apparently are very good. There are examples where firefighters have been able to predict when a building was going to collapse, just by the way the fire was developing, perhaps listening to the sound of a ceiling or a floor collapsing, and so on. It's a rare thing, but some people can acquire it. But it can only happen under very strict circumstances. One is where you have very clear cues, and in most legal cases, we don't have very clear cues. That's why people are bringing their disputes to us. But you also have certainty about what the correct answer is in those situations, like the chess player. The chess player knows exactly how it's going to go. He's played that game many times before. But in law, do we ever know if we're correct? I never know if I'm correct. If I'm upheld by the Court of Appeal, all I know is that the Court of Appeal said that today my errors were not palpable and overriding, right? They never say that you were correct. So the circumstances just aren't there for having that kind of intuitive expertise. Now, I said that good decision hygiene is an important thing to have. It doesn't solve all problems, even in the judicial world. And this brings me to confirmation bias, which is something you've probably all heard of. Essentially, it means when judgment and justification are two separate processes, judgment comes first based on educated intuition, and justification is undertaken next. And this author, Jonathan Haidt, who's a psychologist, says, confirmation bias is among the most important psychological ideas that can be taught in law school, and of course, it isn't. Confirmation bias happens when, let's say you have a situation with good decision hygiene. You have skilled lawyers, you have evidence on both sides, good witnesses, time to reflect, and so on, writing reasons afterwards. The problem is that if you introduce into that scenario a situation where the judges have very heavy caseloads and they have too little time to deliberate and write reasons, they fall back on their intuitive decision making. So it doesn't matter what happened up to the point where the judge leaves the courtroom. At that point, they may be back into a system one fast thinking scenario and susceptible to biases and cognitive illusions, and especially confirmation bias. And the more I've looked into this, the more concerned I am about how this impacts judicial decision making, because I think it's quite natural for a judge to come out of the courtroom after hearing submissions and so on, to think, I'm inclined to decide in favor of the plaintiff, and I know I have to get my judgment out in a week. So I'm going to go find, and this is all unconscious, by the way, this is not very deliberate. I'm going to go find the things that support an outcome in favor of the plaintiff, and that's the way my judgment is going to be written. So we've fallen into a situation where someone is not engaging in the kind of deliberate process we would hope them to engage in, because they're forced into it by circumstances, the press of time and volume. So the other thing about this that concerns me is this is an extremely robust kind of bias. What I mean by that is, it turns out that for that judge just walking out of the courtroom, only a little bit of confirmation is necessary in order to solidify that judge's opinion about how the case should be decided. We tend, when presented with some confirmatory evidence, to be very certain about the correctness of our decision. And even worse, when presented with the contrary evidence, so perhaps the judge will go looking at the evidence supporting the defendant's case. The tendency then is to discount the value of that evidence and say, well, that's rather weak, or not persuaded by that. And by that being even further reinforced by their initial reaction, their intuitive reaction to how the case should be decided. So going back to my climate change thing, if you were to go to someone who agreed with Donald Trump and presented to them all of the evidence contrary to the opinion that climate change is a hoax, the person is most likely going to discount the quality of that evidence and say that it's very weak and believe even more strongly that Donald Trump's perspective on that is correct, and vice versa with respect to Al Gore. So this is how ideas can get really firmly entrenched, and how we can get really firmly put into two camps on a given issue. Confirmation bias is a big problem and is one of the reasons why that happens. Now, this little adventure I've had looking into judicial decision making has taken me into other areas to see what's being done about decision making in other areas that are very important, like the sciences, physical, biological, and social, and medicine and beyond, aviation, engineering. I've had a look in all of these areas to some extent. I don't claim to be an expert, but you don't have to go very far looking into recent articles on decision making in all of these disciplines to find that there's something referred to as a crisis. In science, it's referred to as the replication crisis, and it's the phenomenon whereby the results of scientific studies cannot be replicated. So just look at science for the moment, and these numbers are the rates at which scientific studies can be replicated. More to the point, what the rate of failure is in replication. So 87% of chemical studies cannot be replicated, 69% of physical studies, engineering, 77% of biology, and so on, 67% of medical researchers. 50% of scientists who have published studies can't replicate their own work. So this is a big problem, right? So that what is happening in science and medicine and so on is an effort to redress this problem by looking at various ways to eliminate bias. And we think of science as being the most reliable, evidence-based kind of decision-making we could ever have, and yet bias enters into it. And the kinds of bias we're talking about here are publication bias is one. You can only get a scientific study published if it shows something interesting. Right? It shows that whatever you're studying has had some statistically significant effect that's measurable. Well, people who are collecting data know that, and they tend, in some cases, and the numbers seem fairly high, to look at the data in a way that would favor a conclusion showing such an outcome. Publication bias is what that's called. There are also financial incentives, and this affects my world because I do a lot of trials where pharmaceutical companies are arguing about patent infringement, and there are scientific studies that are in front of me all the time, and many of them are authored by physicians and researchers who are employed by the pharmaceutical companies themselves. So there's a financial incentive for those authors to arrive at a result that favors their employer. So this is a serious problem, but it's all over the place. Just a couple of days ago in the New York Times, this headline, "Top Cancer Center Seeks to Retract or Correct Dozens of Studies." So it was falsifying data on the success rate it was having in treating cancer patients. So in medicine, this is a recent study of decision-making in the emergency departments of American hospitals. Just the top figure is important for our purposes, I think, but 1 in 18 patients are given an incorrect diagnosis. That isn't a big number, you might say. It's only about 5%, but look at how many millions of people are presenting themselves to emergency rooms in American hospitals in a given day. And 1 in 50 of those suffer an adverse event as a result. So these are serious problems. 1 in 350 suffer permanent disability or death. And those numbers you might be able to live with, but except if you look at the source of them, 89% of the errors were cognitive errors, the kind of thing that I'm talking about this evening. Faulty clinical assessments, poor reasoning, poor decision-making, making inferences from nonspecific or atypical symptoms. So it's a crisis in medicine as well. Okay, can good judges make better decisions? Surely we can, but how? Sure, if we had more time, more judges, more follow-up, if we wrote reasons in every case and didn't decide things quickly, as we sometimes do now. But I think the most important thing is more training. Judges, at least in Canada, receive 0 training on how to make decisions. Judges in Canada don't know anything about this that I've described to you, except those few who attend the courses that I put on for judges. I just did one last week. Now, let me say to you, this was for judges and administrative tribunal members. I think there are about 2,000 judges in Canada, probably 10,000 administrative tribunal members. Attendance at my one-day online program, 60. Well, actually, pretty good. But we're never going to reach all of those decision makers by holding annual programs of that magnitude. My view is that judges have to take these courses. One reason why it's difficult to get judges to come is the message we give them is, you know what, your job's a lot harder than you thought it was. And they already think it's very hard. So they actually go away from these courses feeling a bit discouraged. It's not like the courses that we give on evidence or judgment writing even, that people go away from those courses energized. So I think that this training should be mandatory, and the only way to do that is to give it to new judges who have to take some training upon their appointment. This should be part of the training they receive when they're first appointed to the bench. A quick word about checklists, because this is one of the strategies that's being used in many different areas, and most certainly in aviation and medicine. And huge improvements have been made in medicine in particular, giving checklists to surgeons, giving checklists to doctors who are attending patients in surgeries. The rates of infection and errors have been reduced significantly by using checklists. So it's just something to keep in mind. We have them in law. It's not like it's foreign to us. We sometimes call them multifactorial tests rather than checklists, and that's maybe a more palatable label. But something to think about, for example, for my judges who are deciding those cases quickly, what if we could devise a checklist that would tell judges what they should be looking for in deciding whether someone has presented a fairly arguable case? I have no doubt that that would be a great improvement. Pilots have checklists, obviously. Airlines as a whole, for their maintenance people and for all of their staff, flight staff and otherwise. You can be sure someone at Boeing this week got a new checklist that said, tighten the bolts on the doors of those 737 MAX 9s. There's a famous case referred to as a miracle on the Hudson, you've probably all heard of, where a pilot brought down an A320 aircraft onto the Hudson River. It's a very good movie. I just watched it out of curiosity, but I've also read quite a bit about how the pilots acted in the cockpit when presented with that emergency, which was caused, I apologize, for Canada geese, who caused the problems flying into the aircraft's engines. But first thing they did, they reached for a checklist, even under those extreme circumstances. And that was Airbus, E320. They had a checklist, what to do when you have dual engine failure. Problem is, it was a 3-page checklist, and it was meant to be used at altitudes above 20,000 feet, because that's where A320s generally fly. So if you're up at 35,000 feet, for example, you got a couple of minutes to get through a 3-page checklist, but not when you're at 700 feet, or they eventually got to 3,000 feet before they made the decision to go into the river. But again, the instinct was to go to the checklist, and they got through page 1. So it wasn't like it was useless, but it wasn't intended. There is now a checklist for dual engine failure at low altitudes. Anytime I tell people I'm exploring this subject of judicial decision making, they say, "Oh, you're into AI," and I haven't mentioned AI yet. I think my preoccupation has been to look at the problems that we have with human decision making. Let's sort those out first. Maybe that'll help us devise artificial intelligence that can be useful in the legal world, but that's not the focus of my study. But if you started making checklists, for example, it wouldn't take much more work to go from those checklists to an algorithm. And this has been done in other areas like radiology, reading X-rays of brain tumors, for example. Very good radiologists can tell you, and this has been studied, can tell you the 6 things that they look for in looking at an X-ray to determine whether there is a tumor present. They can tell you what those things are, but they can't see them. So those very radiologists were presented with X-rays and asked to identify which contained tumors, and they weren't very good at it. But if you took the 6 things they said should be on the checklist to look for in an X-ray, an easy algorithm could be devised, and the algorithm is very good. So we could be going from checklists, so long that we could use experts to create checklists, and then we're not far off from having an algorithm. And what we do with that is for others to decide, but we can see how this progression might occur. But algorithms essentially eliminate the kinds of things I've been discussing, eliminate noise, prevent unequal treatment, and reduce errors, and so on. But obviously this is only true if the algorithms have been very carefully devised and with a view to eliminating biases that would otherwise enter into human decision making. This I find a bit discouraging. Be careful with the sources you rely on. You remember one of my early slides had a list of sources. The one at the top was a book called Predictably Irrational by Daniel Ariely. He's currently under investigation at his university for producing biased studies of biases. And his colleague, who is a professor at Harvard named Professor Gino, I've forgotten her first name, she's actually under suspension for having produced studies on biases that contain biased data. And in this kind of bias is, I'm using that term rather kindly here because the allegation is actually that the data has been falsified. But it would fall within what I've been describing as a publication bias, because these people have been producing very well-selling publications on biases. The headline writers have had a lot of fun. This has only come to light in the past few months because the actual studies that these 2 scholars were conducting were looking at the degree to which people could be nudged to be honest. So New York Times, or this is The New Yorker, has a very good article called They studied dishonesty. Was their work a lie? So, imagine. So be careful. So I said these biases enter into all other areas of human endeavor, including the study of biases. But here's the real problem. I hope you don't find this too discouraging. But your brain is not for thinking. And this is why we have these kinds of problems with biases, illusions, and heuristics. Your brain is an enormously complicated organ that regulates everything going on in your body, all of your senses, and so on. Thing is, if you create over time through evolution an organ that's that complicated and can perform all of those functions, it can also do other things. It can compose music. It can create art. It can solve quadratic equations. It can write code for software. It can do all of those things. It can be trained to do all of those things. It's not what it's designed for. And so when you're applying your brain to these kinds of questions, there's the possibility it's going to let you down because it's not really its forte. So that's why these things are all problems, and they're problems for everyone. It's not like you're immune from these problems. You're a human being. These things will affect you. So my very modest suggestion, because judges are meant to be independent and impartial decision makers, we should become more literate about these kinds of flaws in human decision making. And I think I've shown we're actually lagging behind other disciplines in trying to eliminate biases and illusions from our decisions. Yet we're supposed to be the experts. People come to us to make decisions. We should be as good at it as we can possibly be, and to be good at it, we have to understand the kind of phenomena I've been describing. That's my modest suggestion. As I said, I think all judges should be trained in this, and they should be trained upon their appointment. So with that modest suggestion, I thank you.
James has very kindly said he's prepared to answer any questions. So if any of you have a question, do please put your hand up. Wait before you ask it, and you'll be given a microphone. And the reason for that is it means not only can everyone in here hear you, but anyone online can hear what your question is. And if anybody online has a question they want to ask, if they can put it in the Q&A box, I can then access it there. Thank you.
Thank you. My question is, I'm a little bit confused about the checklist versus heuristics. Isn't for a relatively vague test like something being fairly arguable, isn't when someone's trying to develop a checklist, wouldn't that just kind of be a bullet point list of heuristics in disguise?
It could, but you would hope that it wouldn't. So the kind of checklist I have in mind would be to identify what the characteristics of a fairly arguable case would be. And I'll just give you a simple example. If a failed refugee claimant shows you that the decision maker, in this case it would be a member of a tribunal, made adverse credibility findings against him, and this person claims that those credibility findings weren't justified based on the record. You could have, if that's the issue in the case, you might invite the judge to check, and this takes some time, and I've described it as sort of a paradox. When credibility is an issue, we're supposed to be giving more deference to the decision maker, but to do that we have to do more work. And what I mean for purposes of your question is you have to say how many adverse credibility findings were there? Was there support for those credibility findings in the record? Were they identified in the decision of the decision maker those kinds of things, as opposed to, those would be cumulative, not a single question. A heuristic typically would be a single question. A heuristic would be, well, was it a credibility case? Well, then I'm not granting leave, because we're meant to give deference in those cases. So it would actually try to give greater precision to the kinds of things the judge should look for.
Thank you.
I've got a question here online from Julian Roberts, which is more of a proposition, I think, inviting your comment. You've passed over the most common remedy for poor decision-making in the context of courts: guidelines. Judicial training is likely a far less effective remedy. What would you say to that?
Well, I think guidelines could be very important. In fact, I think on my slide I had guidelines and checklists together. But I think that could be extremely useful. But I would think that judicial training should be explored, at least to see whether this could be part of the what we call the New Judges program in Canada, because I think part of the problem here is a lack of awareness of these kinds of problems. Psychologists will tell you, if you're going to address these kinds of questions, you have to be aware that they exist, you have to be motivated to solve them, and you have to have some tools to be able to deal with them. Guidelines could be one tool, checklists could be one, but certainly training is part of the solution.
A point that occurs to me in answer to that is that guidelines tend to set parameters, and they may be helpful to stop people getting right off piste. But within the guidelines, that's where the discretion, the judicial discretion, has to be exercised. And that surely is also the area where the pitfalls of bias can occur.
Yes, you wouldn't want to have guidelines so strict that they determine the outcome. There would have to be an element of judicial discretion, but I don't think that defeats the idea that guidelines might be useful.
Any other questions? There's one in the back first.
Thank you very much for your lecture. I wanted to ask, would you say that these issues of unconscious bias, etc., are more prevalent with first instance judges, or do you think that, let's say, final sort of like jurisdiction, like Supreme Courts, for instance, justices are just as susceptible to these issues?
Yes, I think you're very right, especially the kinds of biases that can be the product of having seen and heard witnesses and lawyers over an extended period of time in a trial. So I think I think you're right that the problem is less acute in appellate courts. I have to say, though, I don't think the appellate courts are the answer to the problem, in that I think it's very difficult for an appellate court, for example, to spot biases that might have caused the judge to rule as he or she did at first instance. They're just not looking for that. They don't see it. The arguments won't be there in front of them. So you would think that we have this system where appellate courts are not always just to correct errors, but to decide matters of legal policy the higher you go. And they're important institutions for that function, but they won't be spotting biases. So I agree with your proposition, but I have to point out that I don't think there's a solution there either.
Thank you for a very interesting lecture. Could I just ask a short question? If algorithms can eliminate biases or defective reasoning, would you think that algorithms could be used in any part of the justice system? And if so, which and under what safeguards?
Well, I think it's quite possible. I've talked to the author of the empirical studies that I gave you a little sample of, about that possibility, because he's now using AI to conduct those studies of our court. And by the way, those numbers come out every year, and it's rather discouraging to find that they're almost the same every year. In other words, we're not making any progress. But he used to hire a team of researchers to do those studies, and now he uses AI to generate those numbers, and he can produce a study in a matter of seconds where it used to take weeks. But I've spoken to him about it to try to solve this very problem. Could we develop an algorithm? Let's start with the checklist that was referred to. Look at the things that judges should legitimately be looking for in one of these cases. One of these leaves or stays, but it could be in any situation where you don't have the kind of decision hygiene that we have for trials or appellate decision making. I think they could be very useful in that situation, and he and I agreed that the way to present that idea is to show judges that they could use that as a tool that would assist them. I went to a presentation today on AI where someone referred to a software program that would alert you if you're about to make an anomalous decision. So that would be helpful. I mean, even if, for example, the AI could tell you with a given refugee file that 85% of my colleagues would grant leave in a case like this, having put the file through the system and come up with that kind of number, I think that would be very helpful. It obviously would speed judges up. Although he pointed out that creates a new kind of bias, and it's called machine bias, that you become over-reliant on technology instead of making decisions yourself. But I think it has enormous possibilities for saving judges time and dealing with decisions that they have to make quickly.
In the tax tribunal, one of the litigating parties is invariably the same. It's the revenue. So I'm wondering if you thought that had an impact on bias.
That's interesting, because in almost all of our refugee cases, one party is the Minister of Citizenship and Immigration. So the immigration and refugee files we get are almost all from failed claimants. And if you look at the rate of success in leave applications, you will find that almost all of the successful leave applications are made by the minister. So if you look at their very small number, they don't tend to seek judicial review from a decision that has favored a refugee claimant. So let's say we have, out of that 16,000 I mentioned, I bet we have fewer than 100 that come from the minister. The remainder come from failed claimants. But if you look at the numbers on their face, it will show that probably 99% of the minister's applications are successful. We tend to get those only when it seems very clear that an error has been made by the decision maker below. So it looks like a bias, but it's actually not a bias. It's explained by, I think, the caseload and which party is coming in front of us. So I think that there's that kind of possibility. Those allegations are made quite often in criminal courts, where you might have a judge who's a former prosecutor who's sitting on a trial, or vice versa, a judge who's a former defense counsel. Allegations of bias have been made in those kinds of situations. So it's possible, but in the areas I've been describing, I don't think it exists.
I've got two questions here online. The first of them is this: how do you think advocates can apply their knowledge of these biases when appearing in court?
There's a book written on this, and there's also a lot of oral history on this subject that passed down from senior counsel to more junior counsel about how to present an argument before this or that judges. But the book that I'm referring to is on legal persuasion, and what the authors do is essentially tell lawyers how they can exploit biases and illusions and heuristics in order to be more successful in court. So they can be used. The kinds of examples I've given about anchoring and hindsight bias and so on can be employed as techniques of advocacy.
And the second question from Nancy Marsh is this: are there any existing models for good decision making? We hear lots about how not to do it, but less about how to do it. Checklists, guidelines aside, I find these rather formulaic and create linear rather than holistic decision making.
That's a very perceptive observation. No, there's very little. One thing that I found instructive is looking at jury instructions, and that's one of my hobbies. I spend a good deal of my spare time writing criminal jury instructions, although it has absolutely nothing to do with my day job as a federal court judge. But I've been a member of our National Committee on Jury Instructions for now 26 years. So I'm spending quite a bit of time drafting instructions. And in recent years, some of the new work that we've been doing is trying to instruct jurors on implicit bias and confirmation bias and hindsight bias. And I found that some of these suggestions for how we can immunize jurors from these kinds of biases helpful in thinking about how I could do it for myself. I'll just give you one example. In some model jury instructions in the United States, jurors are told that when they go into the jury room, they're going to be held accountable for what kind of verdict they would render. So if they're of a mind to convict, for example, they're going to have to tell the other 11 jurors why they arrived at the conclusion that the accused should be convicted. And even being told that, studies have shown this, even being told that heightens the attention that the jurors bring to the hearing of the evidence. And in the jury room itself, if they know they're going to have to explain this, then that process of explanation helps diffuse things like confirmation bias and implicit biases against the accused, because they get challenged on it. We as judges don't get challenged, except once in a while by the Court of Appeal. But I think one thing that one could learn from those kinds of instructions is we ought to seek ways of challenging ourselves. With confirmation bias, some judges have suggested that you should write a judgment that you think would favor the losing party, and then decide whether you really think the other side should win. That obviously takes a lot of work and a lot of effort to try to de-bias yourself from just going about looking for evidence and authorities that would support your initial intuition about how the case should be decided. But maybe you could be challenged by a law clerk or by a colleague, or maybe you could circulate a draft to someone to respond to. When I teach judgment writing, I tell judges that it's a very useful technique when you're writing for each issue, to set out the position of the losing party on that question first. And then the remainder of your analysis is the reasons why you disagree with the losing party's position. Well, I think that actually, now that I've spent more time thinking about this, could be a de-biasing technique. That if you did more than just, in a pro forma kind of way, set out what the losing party's argument was, if you seriously stated the exact position in a summary way, obviously, but in a serious way, the position of the losing party, then you would be putting some check on yourself in your analysis from that point forward. I think that I've been more thinking about how the losing party receives that judgment, and why I suggest putting the losing party's position first, because then the losing party knows you listened to his or her argument, you were aware of what their position was on that issue. But I think it should be more than that. I think it should be a real test of whether your analysis stands up.
There's one more question. We take one more, and then I think it'll be time to wind up.
Thank you. I don't think anything that you've just said, sort of impressive as it was, would help you when you've got the 20 cases a day to decide. So I just wanted to have you techniques that you think helps you to make those sorts of decisions better while still getting through them at the requisite pace.
You want to know my heuristics? No, I don't particularly, although I do, I am sort of self-conscious about doing these now, and try to check my own process. One thing, for example, I didn't include this one, it's hard to call it a bias, but I'll call it a bias for now. I forget Kahneman's term for it. But there's kind of a bias against sloppiness. And a lot of these materials, because they're put together very quickly by the applicants, they don't look like much in some cases. They've been cut and pasted from other cases, and the margins don't line up and the authorities are all boilerplate. But I very consciously put that out of my mind. So that's one thing. I don't go by the appearance of the file at all. And the same is true at the other end of the spectrum. We have some really excellent immigration and refugee lawyers in Canada, particularly in Toronto. And I must say, when I reach into my box and I pull out the applicant's record and see the name of that lawyer on the cover, I think, I'm probably going to grant. But then I say, no, that's not how you do this. And I do go through exactly what I do for every other file in the box. And I have a technique for doing it. I start with the applicant's memorandum of argument. I go to the applicant's affidavit. I go to the respondent's memorandum, and then I go to the decision under review. So I have a methodology, and I think just making sure I go through each of those steps is, in a sense, a debiasing technique. I rather suspect that some judges don't have a technique, and they may be using the kind of heuristic I mentioned before. One thing that I find disconcerting, though, and I keep having to remind myself about this. So if I have my boxes here, and by the way, they're all now electronic, but I think of them as boxes because for 20 years of doing this, they were physically in boxes in my office. But I'll look down at the end of the day, and out of the 20 files, I stand up the ones where I'm granting, and I turn on the side the ones I'm denying. I'll look down at box number 1 that contains 10 files, has 4 standing up, and box number 2 that has 10 files has none. I sort of think, oh, well, I wonder how that could be. And then I have to remind myself, well, that's a very small sample, right? I'll check again at the end of the week. So at the end of the week, I'll have a big long line of them, and I'll look at the whole number. Out of 80, maybe I've granted 10 or 15, something like that. And I'll say that's about right, because the average, by the way, is a success rate of between 15 and 20%. And in all of these studies, you'll find a judge named O'Reilly who's always in the middle of the pack. And I don't know why that is. And I take no comfort in that, because I don't know if that's the right number. There's no way of knowing if that's the correct outcome. I'm not an outlier. That's the only comfort I have.
I think the time has now come for me to bring this evening's proceedings to a close. Just before I do, can I start by saying, James, that I found your talk this evening even more interesting than when I heard it before Christmas, but you've left me worried that it's because I'm biased. Secondly, as you know, we had a dinner in this inn last night to celebrate the appointment of Baroness Carr as the First Lady Chief Justice of England and Wales. And before that, there was a service of evensong in the Temple Church, which was in part a celebration of that appointment. And in the back of the order of service, there were printed excerpts from a document entitled Things Necessary to be Continually Had in Remembrance. And they were written by Sir Matthew Hale, who was one of our great jurists of the 17th century and was Chief Justice of the King's Bench between 1670 and 1676. And looking at those again, I realized how opposite they are to the talk you've just given. Of the 18 excerpts that he wrote in this document, I'll just quote a few of them. 4, that in the execution of justice, I carefully lay aside my own passions and not give way to them, however provoked. 6, that I suffer not myself to be prepossessed with any judgment at all, till the whole business and both parties be heard. 7, that I never engage myself in the beginning of any cause, but reserve myself unprejudiced till the whole be heard. 10, that I be not biased with compassion to the poor or favour to the rich in point of justice. 11, that popular or court applause or distaste have no influence into anything I do in point of distribution of justice. And 12, not to be solicitous what men will say or think, so long as I keep myself exactly according to the rule of justice. Now that was written 350 years ago by a very distinguished judge, and he clearly had in mind some of the problems that we're still considering today. And I've no doubt at all it's very important that we can continue thinking about them if human judges aren't one day to be replaced by robots. Thank you very much indeed, James, for a fascinating talk. Thank you for your insight.
My pleasure.